Welcome to the New Books Network.
Hello, and welcome to New Books in Drugs, Addiction, and Recovery, a podcast channel on the New Books Network. I'm your host, Emily Dufton, and today I'm talking to David Pozen, whose new book, The Constitution of the War on Drugs, was just released. And I mean literally just released, like 3 days ago, by Oxford University Press. Dave is the Charles Keller Beekman Professor of Law at Columbia Law School in New York, and he's written dozens of articles, essays, and book chapters, while also teaching courses in constitutional law and law and philosophy. The Constitution of the War on Drugs is his first book, and I'm excited to talk with him about it today. Welcome to the show, Dave.
Thanks so much for having me on, Emily.
So, before we get started on your book, I'd like to ask a bit about you, because this book seems like a bit of a departure from your previous writing. So while you've definitely written about the Constitution before, looking through your publications, I see articles on things like the search for an egalitarian First Amendment and anti-modalities, not a lot about drugs. So how did you get into our strange little subfield?
Great question. It's true. I haven't written about drugs specifically before. I've written about other topics in constitutional law. What really brought me to this topic was the observation that a lot of the drug reform groups invoke themes and tropes like racial equality, individual liberty, and reasoned government decision making that are the central tropes of American constitutional law. They're the key values and themes that we discuss in common law all the time, and yet none of those drug reform groups ever seem to invoke the Constitution. So I was drawn to that sense of a disconnect or an absence. Where is constitutional law in this social justice reform struggle that sounds in a lot of its key ideas, but nonetheless doesn't actually try to use the Constitution to pursue reform. So that drew me in, and then once I got going, I just got really excited about the more I learned about how constitutional law used to play a big role in drug reform conversations, and wanted to figure out how it fell out of the picture.
I also get the sense you wrote this book because you are not a fan of the drug war. Um, can you
Yeah,
define the war on drugs for us? And can you tell us a bit about your feelings on it?
yes, I take as a premise that the war on drugs has been uh, a colossal moral and policy failure, however you measure failure. And that's not a particularly controversial point within the social science or legal literature, but it's more of a jumping off point for the inquiry into what happened on the constitutional side. What I try to sidestep um, the getting into the precise details of how best to define the war on drugs, which, as you know well, historians debate, and try to say that what I'm really focused on punitive and prohibitionist approaches to drug control. That instead of trying to regulate potentially dangerous substances through education or age thresholds or licensing or through the medical profession, taxes, zoning, what have you, they're doing it through criminal punishment. And so criminal punishment paired with prohibitions on personal use and consumption, as well as sale of drugs. That's this cluster of policies and the approach that I try to address. And defined in that kind of expansive way, the war on drugs predates Reagan and Nixon, really starts in the early 1900s, but then escalates over the course of the 20th century until it's kind of fully militarized by the 1980s.
Right. You say some pretty damning things about this century-long escalation of this prohibitive and punitive approach to essentially illicit drug use, although of course we police illicit drugs as well. But you say that the war has undermined core tenets of liberalism. From the right to self-rule to the protection of privacy to the freedom of religion. You argue that it costs billions of dollars. It breeds distrust for the government and the rule of law. And the most damning thing you say about it is that, despite decades of battle, it hasn't succeeded. The problem is getting worse.
Right. Yeah, that's that's what I mean when I say the war on drugs has failed by any plausible definition of failure, because whether you're concerned about liberal values of personal freedom or autonomy or choice, or you're concerned about racial justice and equality, or you're concerned about mass incarceration, or you're concerned about public health and the safety of drug behaviors and the rates of dangerous drug behaviors. Through any of those lenses, you should be appalled by what we've gotten out of our drug policies in recent decades. So it's kind of, um, uh, it therefore invites questions about if this set of policies was so draconian, discriminatory, and counterproductive. How come law and constitutional law didn't do more to rein it in?
How come all of us haven't done more, right? Yeah, you have a great
Right.
line.
Yes.
Right, right. You have a great line that says, "In the war on drugs, the curves of callousness and stupidity intersect at their respective maxima," which is very well put. And also, I can see like the chart in my mind, and it's almost beautiful with these two curves, yet intersecting and causing so much destruction. Right? I mean, this has been a substantiated disaster. And yet, though, you also write that war is starting to unravel. Right? We can see this through the
Right.
legalization of cannabis and psychedelics, the open discussion and sometimes reversal of laws that were blatantly racist, like the 100-to-1 sentencing
Right.
disparity between crack and powder cocaine, and even Oregon's brief experiment with decriminalization could all be seen as what you call a cooling off period of the drug war as it enters into a new phase. So, could you tell us a bit more about what you mean by this?
Sure. And I'll say on your prior comment about it wasn't just constitutional law, it was all of us who failed to stop the war on drugs. I of course agree it was a policy failure first and foremost. But the book's contribution is to bring in the Constitution, because there's been a lot written about how the war on drugs was politically constructed. How did it survive in light of increasing evidence of its harms? But what's not been written about is the constitutional challenges and what they might have done and did do. Is that and in a country where when we're fighting about civil liberties and civil rights, the Constitution's usually at the center of those struggles, but not here. On uh, on the question of, sorry, I lost my thread. Have we entered a new phase?
Yes, yeah. But let's actually go with that because that's a really interesting question, right? Like you argue that a lot of the previous drug policy changes came from activists, mostly grassroots activists who, yeah, they modeled their campaigns on those who came before them, right? Like civil rights activists, HIV/AIDS activists, international human rights. So they want to change laws, change opinions, change hearts and minds. But you argue that so what's missing is this desire to change the Constitution, which is very different from how most other countries that have changed their draconian drug laws, most specifically regarding cannabis, but in other realms as well, they have actually changed their constitutions, like Uruguay or Canada. But America hasn't. So why not? What makes America unique in this particular way? Why don't we want to change the Constitution when it comes to drugs?
That's a big question and a hard one. I'll say almost all other countries, they haven't changed their constitution in the sense of rewriting it to protect drug rights. Only, I believe, Ecuador has done that explicitly. Instead, their judges have interpreted general rights language to protect drug users, language about autonomy, privacy, and the like. That's the kind of move that was available here too, because we have also recognized, rights of liberty, privacy, equality, freedom from cruel and unusual punishment, freedom of religion, and so on under our Constitution. And in the 1960s and 1970s, lawyers and reformers made precisely those arguments to the courts, got some traction, actually won a number of victories in the direction of liberalizing drug policy at the state and federal level. And then the book tells a story of how that kind of the rise and fall of drug rights litigation and tries to piece together what happened. The basic answer, really simplistically, to well, how come other courts around the world, across many continents, not primarily Latin America and Europe, but also we've seen some out of Africa and Asia, are using constitutional law to rein in the harshest drug laws. The main reason I think we're seeing that happen more abroad than here is the whole way in which other courts now do rights review is pretty different from how the US courts do it. They do a lot more explicit balancing of, on the one hand, the claimed individual freedom, dignity, or whatever other constitutional value is being brought by the person challenging the law, as against the government's interest in sustaining its policy. And they're willing to look critically at whether the government's approach makes sense, even if the rights claim on the other side isn't necessarily the strongest or most compelling. And that has allowed courts abroad to basically determine that marijuana prohibitions in particular are so ineffective and excessive in many cases that they have to be outweighed, they have to be seen as outweighed by the claim to freedom or privacy on the other side. U.S. courts have been much less willing to do that kind of balancing. They look much more categorically and formalistically at rights, and that's part. There's also a lot of historical contingency and other factors, but that goes some way to explaining why the U.S. has actually fallen behind a lot of the rest of the world in recognizing any version of constitutional drug rights.
Well, so then what does our Constitution say about drug use?
Not, of course, nothing specifically, but there are a lot. The book tries to explain that there are a lot of clauses of the Constitution that plausibly bear on drug prohibition, and that reformers have utilized to try to attack criminal drug laws in the past. And so those include the right to privacy that's been recognized under the Due Process Clause of the Constitution. That tends to be invoked when people want to possess or consume drugs in their own homes in private and say they should be spared, state punishment for that. The Equal Protection Clause has been used for racial equality claims about the racist origins or effects of drug prohibitions. The Equal Protection Clause has also been interpreted by the court to ensure that criminal classifications are at least minimally rational. And that was used in the 70s to challenge marijuana's placement in the most restrictive drug schedules on the ground that that's just irrational. It really shouldn't be lumped together with heroin and heavy narcotics. And that kind of guarantee of reasonable, government decision making was grounded in the Equal Protection Clause. I'll be quick. The Eighth Amendment prohibits cruel and unusual punishment, and that's been invoked to challenge criminal punishments for being addicted to drugs, and also just excessively harsh sentences relative to the gravity of a nonviolent drug offense. And then the First Amendment protects freedom of religion and speech, and both of those were utilized in the 60s and 70s to attack drug laws that were seen as undermining people's spirituality or religious practice, or in some cases their self-expression and political protest. So
Right.
there's no shortage of pieces of the Constitution that may be used to attack drug laws, and which ones have been seen more compelling have shifted over time.
Mm. And certainly we've used the Constitution to change our own policies over intoxicant use too. And we've done it twice with the implementation and then reversal of federal alcohol prohibition, right? The
Right.
18th and 21st Amendments. And what I like about them being number 18 and 21 is that it allows me to remember the two legal drinking ages in America.
I hadn't thought of that.
Right, because it
That
used to be 18 and then it got moved to 21. So that's how you can remember both federal alcohol prohibitions, amendment numbers, and the legal drinking ages in America. So that's my hot tip for today.
uh, I'll just say on that the ratification of the 18th Amendment, bringing in alcohol prohibition, partly reflects how different constitutional law was at the time in the early 1900s, when some of the big questions about regulating drugs were whether any level of government, state or federal, had the authority to ban the possession, consumption, and distribution of these substances. And a lot of the questions were about government power. And by the time you get to the mid 20th century, where my book really picks up, those questions have been settled. The state and federal government are clearly understood it by then to have the regulatory authority to ban drugs. That's no longer an active point of dispute, and the question then becomes one of rights. People start asserting that they have, notwithstanding that the government has broad general authority to regulate and even ban dangerous products, nonetheless, I have a right to certain behaviors. And so, after the 21st Amendment, it's just to say the constitutional debates take a new character. They're no longer about the limits of government power so much as about questions of individual right.
Right, understood. But then within that shifted sort of perspective, from government power discussions to rights discussions, your book recovers, as you put it, a lost history of constitutional challenges to draconian drug laws, sort of based on that concept of rights. And in the late 1960s and early 1970s, you've already kind of touched on this. I mean, you had me at lost history because I love that stuff. But this is very intriguing, a lost history of constitutional challenges to drug laws. What's going on here?
I guess the book's a kind of anatomy of a failure.
Mm,
There was this robust, vibrant, interesting constitutional movement in the 1960s and 70s to challenge drug prohibitions. And as I said, it scored a number of victories in state courts around the country and in lower federal courts. And then it fails by the time we get to the 1980s. So by the time Reagan takes over, the constitutional path is already paved for him to escalate and militarize drug enforcement. So the book kind of says that the real window of possibility in which we could have nipped the drug war in the bud. Is that a bad drug pun? I didn't mean to.
All puns
Uh,
are welcome here. That's
yeah,
fine.
or allow the bud to flourish or something. Would was in the 60s and 70s when drug politics were much more fluid. You have, for example, President Carter expressing explicit openness to decriminalizing marijuana, possibly cocaine as well. And you have the kind of a rights revolution taking off, new youth movements, and Vietnam veterans who are supportive of drug liberalization. It's a complicated period with some political currents swirling in different directions. You have documented more than anyone, the anti-marijuana parents movement and how that's rising at the same time and what that would go on to do. But the judges had some political room to maneuver, you might say, in the late 60s and 1970s around drugs, given how many different establishment actors were supportive of liberalization. And constitutional doctrine was quite fluid in this period around a lot of these issues like privacy and equality claims. And so it was kind of an exciting time to think about the constitutional limits on criminal drug regulation. And I'm describing, in a sense, a path not taken. Like what would have happened if those victories had been upheld and some form of drug rights had been recognized by the end of the 1970s, and kind of recovering a moment that's passed us by, but that I still think has lessons for the way common law developed and the way the drug war developed.
Oh, absolutely. I mean, the late 1960s and early 1970s is such an important and really misunderstood time period in American drug history because I think we all assume, like the famous, June 17th, 1971, Nixon launches the war on
Right,
drugs and everything is racist and awful and terrible. And it's like, well, actually, the war that he launched in 1971 was waged with methadone and treatment clinics. Heroin
right,
arrests went down that year. This was a
right.
very liberalizing moment for drug policy nationwide. As you talked about, marijuana decriminalization starts to spread from 73 to 78. You have a far greater emphasis on treatment and rehabilitation, a greater interest in allowing people to sort of avoid the criminal justice system for drug use as opposed to kind of funneling people back in. I mean, this is a big reversal from the 1950s and early 60s when you had the Boggs Act and little Boggs Acts everywhere, where I mean, the prisons were so full of nonviolent drug offenders that Washington D.C. literally had to create a methadone program because their jails and prisons were bursting at the seams. I mean, it's a very I think we misunderstand this liberalizing moment. And I hope that work like yours and hopefully my book, if I ever finish it, will help sort of round out these edges because you're right, this is a zenith. And things like conversations start to shift. So tell us a bit more about some of the biggest actors in changing the narrative about drug users and trying to protect their rights in the courts as opposed to simply punishing them.
Yeah, there are a lot of actors I could bring in here. The I guess I would say um, in civil society there are all kinds of groups who are speaking out in favor of marijuana decriminalization and sometimes broader drug decriminalization, from the American Bar Association and the American Medical Association to the Consumers Union to the National Council on Churches, National Council of Rabbis. All of those groups are supporting some version of decriminalization. So you have kind of elite establishment civil society groups weighing in that direction. You also have a number of government commissions in the US and abroad that are putting out reports on drug abuse and particularly marijuana, all supporting a public health kind of medical response rather than a criminal legal response. And then you have in the courts and in the law specifically the National Organization for the Reform of Marijuana Laws, NORML, founded in 1970, becomes the key litigator of challenges to marijuana laws, and the ACLU in the late 1960s gets in the game as well, and for a while is litigating actively in this space too. And so those are some of the key players we might mention. I'll just note that one thing that was um, different about the constitutional arguments you heard in the 60s and 70s, and like in prior periods, is that they questioned whether and under what conditions the government could criminally ban drugs in the first place. Nowadays, we still do have some active constitutional debates about drug issues, but they're all about procedure and enforcement. That is, just how aggressively are the police allowed to enforce the drug laws through things like surveillance and undercover informants, stop and frisk, questions of racial profiling. We have a lot of important, vigorous debates about the limits of enforcement of the drug laws. But I want to say in this book that those questions, as important as they are, they're all downstream from
Mm,
the first order question of can the government criminalize your drug use in the first place? And with what kind of showing does it need to make? And for what kind of drugs and with what kind of penalties? And that's what was on the table in the 1960s and 70s. The first order question of whether and when drugs could be prohibited at all. So I view us as having drifted away from the central questions here to tackle, which before we get to questions of how drug laws may be enforced, um, when can they be passed in the first place?
right. So how did these groups, Normal and the ACLU, attack or question maybe that concept of can the government criminalize this action at all? What was the basis for their arguments here?
They tended to build on the Warren Court's civil liberties decision. So the Warren Court is the Supreme Court when the Chief Justice is Earl Warren from uh, early 1950s to the end of the 1960s. And it's this famously liberal period in the court's jurisprudence where it's delivering, landmark opinions on privacy, racial equality, and the like. And they groups like Normal, the ACLU, realized that some of the key Warren Court precedents could be utilized to attack drug laws. For example, in 1965, the Supreme Court hands down Griswold versus Connecticut, and that opinion strikes down a ban on married couples using contraception in the home. So it's not about drugs, it's about kind of procreation and marital privacy. But there's a lot of general language about a right to privacy, and the home being a special sanctuary for the experience of one's privacy. And groups like Normal and ACU quickly figure out, Griswold could be very useful. Privacy in the home, is a kind of claim we can mobilize for drugs as well, when there aren't clear harms to third parties. And so that's just one example. But basically, they are building on recent liberal egalitarian opinions from the Warren Court and uh, trying to develop a new kind of drug rights jurisprudence out of them. They're not making the old arguments about how the state doesn't have the power to regulate drugs so much. They're making a new set of liberal arguments based on privacy, racial equality, and freedom of speech and religion above all.
So how did it work out?
Well, it varied, it varied by issue. But the general thrust is early successes, some potentially path-breaking, cases, some of which are still celebrated by drug reformers abroad, but then eventual failure. So, um, when it comes to the liberty and privacy claims, for example, as you know well and have written about, you get a few state Supreme Courts in the 1970s recognizing some form of a right to privacy that covers drugs. Most famously, the Alaska Supreme Court in 1975, Raven versus State, says that Alaskans, under both a provision of the state constitution that protects privacy and under Griswold, that case I just mentioned, and the federal constitutional protections for privacy, have a right to possess and use small amounts of marijuana personally in the home. And so that sticks, by the way. Alaska Raven is still good law in Alaska, and remains our kind of the canonical case from the American system on drug rights. But for the most part, in other states and at the federal level, courts redefine the test for what gets protected as a matter of substantive privacy and liberty to require that a fundamental privacy or liberty right be infringed. And courts are unwilling to find that smoking pot, is a fundamental right. It may have privacy and liberty dimensions to it, but they're not willing to go that far.
Hmm.
And in fact, the very construction of that test, that to possibly win a privacy claim, you first need to establish that you've had a fundamental right abridged. Um, that in part develops out of the drug cases where basically courts, as I tell it, start to get panicked that they've opened the floodgates to all manner of personal liberty claims after Griswold. And so they're searching for new tests and criteria to try to limit close up the floodgates. And partly the drug cases are where that battle plays out and where they try to preserve a space for paternalistic regulation. So that's the liberty privacy claims. I could go on with each area, but I'll just say the in some ways the most straightforward claims were the ones made under the Eighth Amendment, because that explicitly says no cruel and unusual punishment, and in some ways offered up the most straightforward set of arguments, which is that should be understood to require that the punishment fits the crime. And when you have non-trafficking, non-violent drug offenses landing people in prison for many years, um, that is grossly disproportionate to the moral severity of the offense, and that made headway in a number of state courts too before the U.S. Supreme Court really closed down that line of argument. So yeah, I offer that just as another example in a relatively straightforward one of where constitutional lawyers were attacking in the 70s.
Right, right. Yeah, in the end, you argue that this tidal wave was swept back to sea, and
Mhm.
all of the successful constitutional challenges of the 60s and 70s were overturned or minimized or ignored. I mean, you call it a constitutional failure, which is obviously a bummer. But what's interesting to me is that, it is certainly a part of the context of the moment, with courts being afraid, I guess, in post Griswold, that they've opened the floodgates to all kinds of private behavior being allowed. But you also say that it has something to do with protecting drug users themselves as basically a demographic, right? Because they're, rather than being discrete or insular,
Yeah.
drug users are everywhere. Like they're not like a community like the LGBTQ community, or gun owners, or whoever, whatever lawyers are trying to protect, whomever lawyers are trying to protect. But you write that drug users are more difficult, I guess, in a way to defend because their use is still obviously highly stigmatized. But of course, they themselves are, as you put it, an anonymous and diffuse plurality of the population dispersed through all segments of society, poorly organized and largely in the closet. This
Hmm.
is a difficult population to
Yeah.
defend in court.
Well said. The There, I'm lifting off from individual lines of legal doctrine. What were the Eighth Amendment arguments? What were the First Amendment arguments? And I'm stepping back and saying, when do constitutional rights movements tend to succeed or fail? And there's a literature by constitutional scholars about that. And some of those scholars say that one crucial feature of the successful constitutional rights movements of the 20th century um, were that they sought to protect what the court has called discrete and insular minorities. Um, these are relatively cohesive and recognizable groups that share some social identity. And you can think of the movement for LGBTQ rights as very much fitting this model. It's often analyzed in that way. And some of the court's rights doctrines are specifically tied to recognizing the kind of identitarian claims of those groups. We deserve equal treatment and don't want to be demeaned anymore. But what the other sort of group that tends to lose as a constitutional rights movement, the flip side of that story in this literature are the anonymous and diffuse groups who may actually have many more members, but they're not well organized. They don't have a strong sense of a shared identity or an affirmative argument for why they matter, and deserve respect. And they're not organized in a way that allows for effective advocacy. And so that's how I see drug users, in the 1960s and 70s. There are lots of them. There are tens of millions of them, but um, they're not really coming together as a cohesive coalition. And in fact, especially after Reagan takes office, they tend to stay in the closet. And instead, this kind of accommodation has worked out where elites, mainly white, are spared the harshest punishment under our drug laws, while more disadvantaged people and people of color are more vulnerable. And this basically the elites feel they the situation is tolerable for them when it comes out of after the 1980s, and we get this kind of uh, sad equilibrium, where we chug on. But at this moment of possibility in the 60s and 70s, the story is really about how the drug rights movement never does what successful rights movements do, which is figure out how to tell us an affirmative story about what they're for, not just why the government policies are bad, but what they're about, and develop some sense of a shared identity and purpose.
Well, this has had real implications, right? You write since the zenith of the late 1960s and early 70s, constitutional law has helped to validate and entrench defective and destructive policies, which is not good. And you essentially argue that the outcome of constitutional support for a punitive drug war is that it has cost Americans their liberty, equality, and government rationality. I mean, what do we do with a situation like this? It seems like a bummer.
It's it's definitely a bummer. I think the role that the Constitution should play in fighting drug laws that are ineffective and overly punitive is really complicated and hard. And I don't land on a very strong position there. I want to show that many different sorts of constitutional arguments against punitive drug laws are plausible, and that prior generations of Americans and certainly American lawyers understood that these constitutional arguments were plausible. So we should recover this sense of constitutional and not just policy discomfort with punitive drug laws. Now, what might it look like though to kind of operationalize that discomfort, in a way that leads us to a better place? That could take a lot of forms. What I end up saying toward the end of the book is what's probably not going to work is trying to just revive the old arguments, the old privacy arguments, the old free speech arguments. they've been closed off for the most part, and there's a lot of doctrine against them at this point. So I end up suggesting, but nonetheless, there are a whole new set of constitutional arguments that are now plausible, that could be tried. Um, and in addition, constitutional arguments can be made outside of the courts and should be made outside of the courts and addressed to legislators and regulators. So it's not just that courts should recognize people's rights and strike down laws, but when, for example, the DEA is deciding what schedule to place marijuana in the current process of reviewing marijuana scheduling under the Controlled Substances Act, it should care that there are privacy, racial justice, free speech, freedom of religion, implications to what it's doing. That should bear on the regulatory calculus. And uh, so, and also advocates and reformers, outside of government, I think it's another arrow in their quiver to recognize that there's a long history of seeing punitive drug laws as constitutionally problematic that they can tap into rhetorically, if not in litigation. And finally, I'll just say that while a lot of social justice and racial justice movements debate how much to turn to the courts and the Constitution in general, or whether that might be kind of unproductive or a waste of resources or might de-radicalize their best arguments. Here, you have a situation where tens of thousands of people are being prosecuted for drug crimes every month. So, you know, um, whether or not you appeal to judges' constitutional consciences, they're going to have to resolve these claims. They're going to have
Mm.
to deal with these cases. So, in that kind of situation where you have a million plus criminal cases per year, um, I don't think you have to really face the same hard choices that other movements do about whether or not to try to make the best constitutional arguments you can in court, because you're in court all the time, again, like it or not. But as far as what the new constitutional arguments might look like, that could have a chance. At the end of the book, I'll just say briefly, I look in two main directions. One is backward in time toward originalism, and this is what the current Supreme Court purports to like to do when it interprets the Constitution, which is to ask how it was understood how any given provision was understood at the time that it was written and ratified. And that may seem like a very inhospitable approach to drug rights. Surely the framers weren't thinking about drugs, but actually, there are quite a few moves you can make as an originalist that could support drug rights. For example, there's a lot of new historical scholarship about what the framers meant when they wrote the Eighth Amendment and the prohibition on cruel and unusual punishment in 1791. And some of that historical scholarship suggests they had a surprisingly expansive understanding of what was cruel and unusual. And and that long prison terms for nonviolent offenses are quite plausibly cruel under the framers' understanding back in 1791. So you have there's just one example of an originalist argument that is teed up, ready to go from the academic literature. And then the other main direction I suggest we could go is looking not backward in time, but abroad, and looking at what courts and other constitutional courts in other countries are doing what they call proportionality review, asking whether incursions on people's privacy, autonomy, and the like are proportionate to the government benefit. And through that analysis, finding some marijuana laws in particular to be uh, unjustified. And although the U.S. federal courts haven't wanted to operate in that way, I suggest that a number of state Supreme Courts have actually gotten quite interested in proportionality, and so would be a good place to try out those arguments. I still see room for constitutional attack on drug laws. It just may look different than what normal and ACLU were doing in the 1970s.